It says by striking the child about the head and body with your hands and feet and choking the child. That's what this alleges. Do you understand what you're charged with here? We call cause number 25 CR 1459, the state of Texas versus Reanella Monique Gage. That is you.
Yes, sir.
President. With your attorney, Ms. Minaldi, and the state's attorney, does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about March 20th, 2025, in Jefferson County, Texas, you committed the third-degree felony of injury to a child younger than 15 years of age. It says by striking the child about the head and body with your hands and feet and choking the child. That's what this alleges. Do you understand what you're charged with here?
Yes, sir.
If convicted of this, you face a third-degree felony of a term of not more than 10 years, less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached. Will you be pleading guilty? And then not found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fine $500. And this is a form of probation where there would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
I understand.
How do you plead to this, guilty or not guilty?
Guilty.
No, you pleading guilty voluntarily, that is on your own free will, because you are guilty.
Yes, sir.
I'll show you. It's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes.
Understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence
No,
without objection. It's admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been good to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. So help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Is the pre-sentence report waived here?
Yes, Judge.
Judge, I believe when this first came out, she took some classes with CPS and got those completed. CPS is backed out. The environment she's living in right now, she needs to come back home to mom and the state after discussing and with defense counsel and looking at this, believes it'd be in the best interest for the child that she'd be allowed to go back home to mom. He go back home to mom, sorry. And I know at the time that there was some things going on that we ended up indicting her for. I'm glad we did because I think it straightened a lot out.
Yes.
It's not unusual for children to need discipline. I mean, that's important.
Yes, sir.
But there is no discipline I'm aware of that includes choking, which is what this says happened. Or kicking, punching, or slapping. And apparently the reason all this, he brought toys into the bathroom, into the bathtub. That's what this says. Well, choking, when you choke somebody, there's only one reason you do that, and that's to seriously injure or kill somebody. I mean, that kills people when you shut off their breathing. They have to breathe to live. So,
Judge, along with the parenting classes, we've also, I think, included the part of the conditions of probation will be that she'll have to attend and complete an anger management program, which I think will further help.
all right, anything else, Dan?
No, Judge.
Where's the child now?
He's living with his maternal grandmother.
What's the,
And there's
the law?
And she's been doing supervised visitations per your order earlier, so they're still having contact.
Has family courts gotten involved in any of this?
CPS has cleared everything and she's done everything that's been required of her, which is all of the circumstances going into the decision for this resolution today.
I guess something like this won't be repeated, huh?
No.
Nothing, and you were pleading guilty voluntarily and because you were guilty in this, is that correct?
Yes.
Is that yes? Okay. If nothing further, I'm going to make the following findings: that the defendant is pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation. There are a lot of them. But most of these are terms and conditions of probation that all of us, that are terms of life that we all have to follow, beginning with don't commit an offense, avoid injurious, vicious habits, don't associate with disreputable people. These are all good ideas for everybody, but you're going to be required to follow these. They've also completed anger management program.
You're welcome.
That will be supervised by the probation office. This will be for 10 years. You do well, it can be shortened to 1/3 of this. There is no fine.
There's a $500 fine.
It's $500. There it is. Once you slip $500 fine, the probation officer is going to go over these probation terms, make sure you understand them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 10 years in prison. So it's serious, and this can be shortened. So, how many children?
We have no child.
Here it is. Please see the probation officer and begin probation. Thank
Thank you,
you.
Joe.
Yeah, just stand right there. Okay, sorry.
It's other.
And you were a juror in this Xavier Senegal case that we're trying to wrap up in cause number 22-40440. And okay, I think you were the first juror selected out of all of this, but you didn't appear yesterday, right?
Yep.
What happened?
Because
that's serious.
well, I mean, I talked with the district clerk. I have a
I don't
wife.
care. That's district clerk doesn't run my court. But it's, you were ordered by me, not by her. You were
Yeah.
ordered by me to appear as a juror. You were selected, and so we went into the trial. Now, we replaced you because of what information we had, and we needed to move forward. And an alternate was replaced, but why were you not here?
Well, I have a wife that's late in pregnancy and we're older.
I didn't know that.
Well, I tried to explain that. And I mean, the gentleman beside me has explained something, but I was under the impression, Judge, that I was getting exempt because of my situation. If I would have, and they just said I had to come give a statement. If I would have known that, I would have been here. It was not anything out of
You didn't
disrespect.
think you were supposed to be here.
Correct. I got told it was taken care of. If I would have known
Yeah,
that he
well,
didn't override you, I would have been here. So that, I mean, from the bottom of my heart, I
But
I
we-
apologize for that.
We had we called your name and you were in the jury box, right?
Yes, sir.
Okay. Well, yeah,
Don't know
of
what-
course, that's an inference that you're in the jury. How's she doing?
She's doing fine. She's 41 and I'm 40. This is our first kid. So, and so they're making us go to Houston a lot here in the last couple months. So I have to be available at any time.
Okay, there was no objection.
just
Under those circumstances, right, Joe?
Yes, no.
And so there's not a problem with y'all, and that's not a problem with me, and we've got it covered, but on the record, we needed to explain on the record, because
Yes, sir.
if somebody ever later complained, well, where was Mr. Pike, somebody else was replaced, and it's not clear on the record why Mr. Pike, who was selected, was not excused formally, and what was the reason for the excuse, which is what we're doing.
Yes, sir.
Okay, you're free to go.
Okay, well, it won't happen again. I promise you that, so.
Things always happen. It's just a matter of
It was explained to me a
record
different
and
way.
figuring it out legally that it's not a problem. It doesn't jump up and cause a problem with the case as we progress, because we don't have the time and ability to retry anything.
Yes.
You know, it's just overwhelming. So we've dotted the i's, crossed the t's. And everything's fine. That's good. We'll see you next time.
Yes, sir.
Okay. Thank you. So he drives you around? That's who takes you everywhere?
Yes.
Well, it's on the record. If we catch you otherwise, you can imagine shame on you. You would be held severely accountable because these are serious offenses, especially when you've got a child. How old was the child? How old was your child at the time? You don't know?
She's 3.
3 years of age, an infant, and you're intoxicated and committing crimes with an infant in the car, and you put the infant in harm's way? You see anything wrong with that?
Definitely do.
Okay. Because I think everybody else does too. You said 3?
Yes, please, Judge.
Okay, it's done. Reset for 3 weeks.